number 101, the people of the state of New York versus Ramee McCullum. Good afternoon, counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Benjamin Littman of Counsel to Appellate Advocates, and I'm here on behalf of the appellant, Ramee McCullum. At the outset, I would like to reserve 2 minutes of my time for rebuttal.
You may, sir.
Thank you. Your Honors, this appeal presents a single, discrete issue of first impression with significant ramifications for New York City's poorest residents. This Court should decide that issue, consistent with the prevailing rule, and hold that occupants of an apartment, like but even more than most bailors.
All right, well, before we get to that, I'd like to discuss a threshold issue which deals with preservation, and I just want to make sure I'm understanding your argument correctly, which is that you're conceding that some of your arguments are not preserved, but that there's an exception to the preservation rule because you could not have raised these issues at trial. Is that, in fact, a correct understanding of your position?
That is correct, Your Honor.
So how do you say that when in the record at page A263, we have that was introduced at the hearing, the marshal's legal possession, how do you say you couldn't have known at the time of the hearing?
Your Honor, at least 3 reasons in response to that. So first, the context in which that document was submitted. This was a hearing that was focused almost exclusively on the question of standing. And again, there was a moment where the issue was about whether the eviction, which was what was presented by the people to have occurred, was in fact legal. So there was this dispute as to whether the marshal or others had produced documentation to prove the legality of the eviction, and the suppression court allowed the people to reopen the hearing to produce such documentation. And again, in the hearing court's language, to produce the documentation that allowed the marshal to go and evict. And again, the appellate division understood it the same way, which was that the document was produced in the context of proving the legality of the eviction.
What would have prevented defense counsel from looking at that and saying, whoa, this wasn't an eviction at all, this is something completely different, and arguing, actually, I don't see why he couldn't have argued a bail or bailee relationship either way, but and just to take this one step further, let's even assume that there would be no way of knowing that. What about the fact that when this was discussed in the trial, no objection was made, no request to reopen the suppression hearing? So,
Sure.
So it seems to me that there was at least one, if not more, opportunities to raise this issue, and then, so why would it fall within an exception to the preservation requirement?
Sure, Your Honor, and I think you're asking 2 separate questions, if I can deal with the first one at the outset. So again, I was initially describing the context in which this document was introduced, and again, it was introduced in the context of proving the legality of what everyone understood to be an eviction. What Your Honor was first asking about was the content of that document, where it says marshal's legal possession at the top. As we set forth in our reply brief, the actual content, if you look at the language apart from the heading, it says the landlord has possession of these premises. Now, in an eviction, the landlord also has possession of the premises. The distinction between a legal possession and eviction is possession over the property. So there's no mention whatsoever in the content of the notice about the property.
In either case, though, somebody has possession of the tenant's property. It's either the marshal, or it's the landlord, or it's a storage facility, or it's something, right? So what difference does it make? Why couldn't that argument, which I understand is the primary argument you're raising now, have been made either at that point or subsequent to that point before we get to a verdict?
Yes, Your Honor. I'll deal with the suppression hearing first, and then I'll go to trial, which I understand is your other question. So with respect to the suppression hearing, there is a distinction with a difference between an eviction and a legal possession. There is a judicially blessed administrative regulation which governs the conduct of marshals in New York City, and that is the Handbook of Regulations that we cite throughout our brief.
But how do you say that affects the issue of the bailment?
Well, we don't concede that there would necessarily be a bailment in the context of an eviction because the regulations provide for a bailment only in the context of a legal possession. They're silent as to whether a bailment is created in an eviction. And again, even if there were a bailment in the context of an eviction, as the people recognize, there would be different bailees, seriatim, as they put it, starting with the marshal, then to the moving company, and finally with the storage company.
But he knew his property was in the apartment, right? Okay. So if there is going to be a bailment, wouldn't it at that point be on the part of the landlord?
Well, again, the break-in and the subsequent search occurred almost immediately after the legal possession was effectuated. So I don't think the fact that it occurred so close in time would have tipped off defense counsel to realize that this was necessarily a legal possession. Now, with respect to what I was mentioning in terms of the seriatim nature of the bailees, to the extent that a bailment were created in the context of an eviction, it's important because one of the exceptions that we point out in our brief when bailors do not have a reasonable expectation of privacy is when the bailee is an agent of the government. So in that case, as the people concede with an eviction, the marshal would at least be one of the bailees seriatim. So yes, there would, to the extent there's a bailment, it's much more attenuated than in the case of a legal possession. And you arguably have the situation where an agent of the state is one of the bailees, which falls into this exception where the reasonable expectation of privacy is diminished. Now, if I can transition to the point, the second point Your Honor raised, which is put aside the hearing, what about at trial once this issue of legal possession is definitely raised by the marshal? And as we explain in our brief, the reason that defense counsel did not fail to preserve it by not moving to reopen when that option was available to him is because the preservation rule requires, 470.052, requires that the issue be raised at the time or at any subsequent time when there is an opportunity of effectively changing the same. Again, on our appeal, we're contesting the fact that the suppression court did not issue any findings of fact and conclusions of law. But it's inarguable that the suppression court ruled on the merits. So the defense counsel was stuck with the fact that there was a ruling on the merits such that...
Wait. People move to reopen suppression hearings during trials all the time. You have two cops in a radio motor patrol car. Only one gets called at the suppression hearing. You go to trial. You've had a ruling, and the second cop is now called at the trial and says something very different than the first cop. The windows weren't tinted, or they were tinted and I couldn't see in. You don't have an obligation to move to reopen even though there's already been a ruling?
No, Your Honor. I think those are distinguishable circumstances. The example Your Honor was giving, as I understand it, applies to a merits decision on the merits of a suppression claim.
I'm having the same problem, though, because if the argument is he couldn't have known, therefore it couldn't have been preserved, but then at trial he clearly did know, in the way I understand your argument, so therefore even if it's a losing argument, you have an obligation to make some effort at preservation, and I don't see it here. I'm having a hard time finding it anyway.
Again, Your Honor, the standard under 470.052 is that you have to raise the issue if there is an opportunity of effectively changing the same, meaning the prior decision. Here, there was no opportunity to change the prior decision if defense counsel had moved to reopen on the grounds of standing, because defense counsel was stuck with the fact that the suppression court had ruled on the merits.
The suppression court didn't say, and this is one of your objections, understandably, what the decision was based on. And it seems to me that the appellate division disagreed with you and seemed to suggest that it implicitly made the decision based upon standing. So we don't know. So how can you say that it was too late?
Well, again,
maybe it was on standing. So you move to reopen and you go back and find out.
Your Honor, I think the point is that it was as to both. That's the point that we make in our brief, which is the only language that the court provided.
Making that assumption now. does that really explain why you wouldn't make the motion to preserve the argument once you hear the evidence, you see the evidence at the trial?
Yes, I don't think we're making that assumption now. I think anyone at the time, having gone through that suppression hearing where almost the entire focus was on standing. Again, it was standing, and then there was a reopening of the suppression hearing on the issue of standing. And then, again, the only language the court issued in terms of a ruling is that the defense has not met its burden and the people have met their burden. So clearly, that language applied to standing, and it also applied to the merits. So at trial, when this issue comes up with respect to illegal possession, defense counsel is stuck with that ruling and did not have an opportunity of effectively changing the same.
I just want to try and if you
Yes.
might, Chief, clear up exactly where you are claiming that there's standing, expectation of privacy.
Yes.
So there's a Tupperware with some bullets in it. You're not claiming any expectation of privacy as to that.
Nothing in plain view, correct.
Okay. So that might make it easier. You're also not claiming an expectation of privacy as to the room itself.
Correct.
You're not claiming any expectation of privacy as to the two guns that are on a shelf in plain view,
Correct.
and not as to another gun that is also in plain view in like a blue glove or wrapper or some kind of thing like that.
Correct.
You are claiming expectation of privacy as to a gun that's in a brown or black box, single gun.
Yes.
And as to 4 guns that are in a larger case that has a picture of a forest on the outside.
Correct.
Okay. I got
Thank-
it.
The closed containers.
Yes, which has a special primacy in Fourth Amendment jurisprudence. Thank you, Your Honor.
Thank you, counsel. Counsel?
May it please the court, my name is Solomon Newboard and I represent the people. The defendant could have moved to reopen CPL 710.40 subdivision 4 provides, if after a pretrial determination and denial of the motion, the court is satisfied upon a showing by the defendant that additional pertinent facts have been discovered by the defendant which could not have been discovered with reasonable diligence before the determination of the motion, it may permit him to renew the motion before trial, or if such was not possible owing to the time of the discovery of the alleged new facts during trial. So the defendant could have moved to reopen during trial. In fact, on appeal to the appellate division, the defendant claimed that trial counsel was ineffective for failing to do just that, for failing to move to reopen the suppression hearing at trial. So now the defendant is retracting that argument and saying, whatever I said to the appellate division was wrong.
So then is the appellate division decision all
The-
on interest of justice jurisdiction? Reached an unpreserved question? Or
I think
unpreserved
that-
claim, excuse me?
Yes, I think that
Does it say that anywhere?
it doesn't, but this court is not bound by what the appellate
I
division.
understand that, I'm asking you.
No, I don't believe that they said that they were.
But they did start their opinion by saying, we're presented with a novel question of first impression.
That is correct, Your Honor.
Seems a bit odd if you think it's not preserved to reach that question.
I can't speak for the appellate division, but I could urge this court not to reach an unpreserved. Now, again, the appellate division also has interest of justice jurisdiction, and so they reach unpreserved claims in that interest. So they did have to review that claim regardless, even if it was unpreserved, but this court may not. And so this court should not go on to consider
But
the
even
merits.
if you, putting aside what happened at the trial, aren't they arguably on notice through the exhibit that I was referencing before? And don't they, as part of their burden in preparing for this hearing and making these arguments, have some duty to understand what transpired and how evictions happen in New York City? I mean, this whole legal possession developed out of changes to how evictions are handled.
Absolutely, Your Honor. I was just pointing out that at the very latest, by the time of trial, he could have moved to reopen. But certainly at the time of trial, he had the document. At the time of the suppression hearing, he had already the document, and it plainly stated that this was a legal possession. And the defendant is trying to have it both ways. On the one hand, he says that the people refer to it as an eviction when in fact it was a legal possession, but then when shown a document that says that it was a legal possession, now tries to have it the other way and say, well, legal possession could mean an eviction. You can't have it both ways. So either he rises from the claim that the word
It
eviction
is
is...
hard to read the record without seeing that no one at the suppression hearing thought that this was an eviction, as opposed to a partial eviction with the...
I would just point out, Your Honor, that what happens in New York City is that the judge issues an eviction order. It's an eviction. There's an order for eviction, then the marshal comes to the premises and gives the landlord...
I don't know if that's exactly correct, frankly, based on my experience sitting in civil court. I think the judge issues a judgment on the special proceeding, on the petition, and then the actual order of eviction becomes a ministerial function that flows from the judgment. A judge never actually signs a warrant of eviction.
You're correct, Your Honor, but that order permits an eviction, and then it becomes the
That is
landlord's...
true.
I'm sorry, I stand corrected, but then the landlord has the option of proceeding pursuant to the authority that would allow for a full eviction to then opt for a partial eviction, and in this case, he opted for a partial eviction. And going to the merits of the claim, as part and parcel of the creation of this bailment, there had to be a full inventory taking by the marshal.
Is that the same as a search of closed containers? Isn't this inventory a general inventory of property, and also to make sure that there's nobody in the apartment that's remaining?
I would like to read what it says in the quote from the marshal's handbook that's approved by the appellate division. It says, all marshals are required to prepare a written inventory of all items contained in the premises of any tenant to be evicted. And I'll skip to a little bit further, and it says, all valuables such as money, jewelry, negotiable instruments, etc., should be inventoried even when the items are small enough to fit into a carton. Any valuables which the marshals, in the marshal's opinion, need to be safeguarded should also be inventoried. The inventory should reflect the valuables, that valuables are being safeguarded. To safeguard these items, the marshal...
First of all, it doesn't talk about going into closed containers, but also there was testimony here by the marshal herself that that's not how they generally did that. But leaving that aside, even assuming everything you say is true, could there still not be a Fourth Amendment issue or a right here to what's contained in these closed containers? In other words, you have to go get a warrant before you can open them. You can take them, you can seize them, you can, say what you see is there. Just seems to me that this manual doesn't necessarily deprive a tenant who is being evicted of all rights in all property.
Well, first, Your Honor, given that there's the diminished expectation of privacy because there's going to be a full inventory, and it does allow to even search for such things as jewelry and cash and to inventory it, and therefore there is that diminished expectation of privacy, and this court in People v. Natal said that where the defendant was arrested...
Could they have searched somebody's phone for the contents of the phone if it was there?
No, Your Honor, because that wouldn't be part of the inventory that the marshal, even conceivably, wouldn't be able to say, I'm inventorying the content of a hard drive.
But she
Let's say
said, but
it's
she
all in a
testifies
safe
the
box.
main point of this is to ensure that there's no one still on the premises. And
Well-
that's why she's looking in closets, that's why she's looking around to ensure no one else is on the premises. So why are you opening a small box to do that?
Well, first of all, Your Honor, the law doesn't depend on what the marshal, this particular marshal's
No, but I
understanding
thought your
of the law
argument
is.
was in part that the defendant in this case would have, actually, you're calling it diminished expectation, but I think you're really saying no expectation of privacy, given that, at least at the initiation of this eviction process, there's a government official, a marshal, who's doing an inventory search.
Correct, Your Honor.
I know you have another argument related to the officer once they come. That's a different story.
Yes, there's that argument as well, but
Yes.
aside for that, in the creation of a bailment, the Supreme Court in Rawlings versus Kentucky held that there was this short duration of a friendship between the defendant and someone whom he dumped his drugs into her purse, and the police came and asked her to dump out the contents of her purse, and she did, that there was no expectation of privacy given the nature of the relationship between the defendant and the holder of the purse. And the same thing here, whereas the appellate division accurately described, this was a reluctant bailment where there were two choices for
But even
the
in an
for the landlord.
involuntary bailment, the bailee is still responsible.
Responsible, but is not
For the-
responsible for
the property,
For the
for
property,
not
but not for
creating
protecting
damage.
but not for protecting the privacy interests of the
No, but this is a
bailiff.
question of what are reasonable expectations of privacy. I understand that point that you're making. I'm not saying it's not without some punch to it. But this is about the defendant's reasonable expectation, what he subjectively and what society objectively are willing to recognize.
I would just like to just finish with a policy.
Before you finish,
I'm sorry.
are you conceding standing? Forgetting about whether or not, it seems to be clear in my mind that the Marshal's Manual doesn't supersede the Fourth Amendment, but are you just conceding standing in and of itself?
No, Your Honor, I'm arguing
And that's
that there was,
because of preservation.
aside from preservation, I'm arguing that there was no standing. But the defendant makes much about the policy of with regard to the indigent community. But if this court were to put its thumb on the scale and say that with a full eviction, there is no Fourth Amendment protection, there is no requirement by the marshal or the storage house to protect the defendant's privacy interests, but that a landlord does have to protect the privacy interests of the tenant, that's a rule flowing from bailment, which would mean that the landlord would have to protect the privacy interests throughout, and so during that 30-day period, the landlord wouldn't be able to show the apartment to prospective tenants because under the law of bailment, the landlord would be
Well, they
required
might be
to
able to
protect
show the apartment, but that doesn't mean they're going to open boxes for the prospective tenant to look inside.
But given that the landlord would, under the law of bailment, if this court rules that under the law of bailment there's a duty to protect the privacy interest, then prospective tenants should be able to go into the apartment at all, and putting the thumb on that scale wouldn't be a terrible outcome for the indigent community, because then landlords would opt for full evictions over partial evictions, which the defendant in his briefs argues extensively would be a terrible outcome for the indigent community. And so, for policy reasons, that should not happen.
Thank you, counsel. Mr. Littman?
Counsel, can you just clarify what were the bailment arguments that I know in your brief you say are the only ones that were, given the record, available to counsel? What are you saying are the arguments that indeed were made?
The arguments that were...
Not regarding bailment, excuse me, regarding the propriety of the search.
You're asking about the merits arguments?
Yes.
Yes, there were merits arguments made after the standing arguments, which again took up the bulk of the hearing. The merits arguments concerned whether the police officer, after having arrested the trespasser, which was the husband of the tenant of record, whether after arresting that man upstairs, the officers or the officer was within his right to go down to the bottom of the apartment and search the two separate bedrooms. And then there were additional arguments made about
The closed
moving.
containers. So, and then what are the arguments that were made with respect to standing?
Yes, the arguments that were made with respect to standing were all made under the assumption that this was an eviction. So the arguments were made that, A, it was not a legal eviction, because I think there was a concession made.
Wasn't there also a question by the court about whether your client was admitting possession or ownership of a gun, and they maintained that they didn't, which would clearly say, I don't have standing because I'm not asserting a possession or ownership interest in this property?
I don't recall that, Your Honor. I apologize.
That colloquy with the court at the suppression hearing? All right. I'll go back and check the record.
Yeah.
So
Maybe.
what were the standing arguments that
Yes,
were made?
the standing arguments were that the eviction was not legal, that even if it were legal, it did not.
It's not signed by a judge? What was the argument?
Yes, I think that was essentially the argument, and also that it would not have applied to my client because he was not there at the time and was not aware of what was going on, as opposed to the tenant of record.
So as to the closed containers,
Yes.
why does your argument, your Fourth Amendment argument as to standing, depend on whether this is an eviction or a legal possession? Or does it?
It does. So again, I think what my opposing counsel mentioned at the end was that we are asking the court to rule that in an eviction, there is no reasonable expectation of privacy. That question is not before this court.
Even in the closed containers?
That question is not before this court. What we're saying is that in the context of a legal possession, by regulation, there is a bailment created. And again, the bailment in this circumstance is not a reluctant bailment. It's a chosen bailment by the landlord who anticipates that the landlord-tenant relationship will be resumed. This is not a step.
You're really saying there may or may not be a difference, and you're just not going to answer whether there is in your view.
We absolutely believe there's a difference. There's a difference because the regulations provide for a difference. And also in practice, we know that the number of legal possessions outnumber the number of evictions by 44 to 1. In 2017, which were the most recent numbers we had when we
So
wrote our
were
briefs.
this an eviction, they could open the containers?
It's
That is, there'd be no standing, no expectation of privacy in the containers?
again, that issue is not before the court.
I understand that, but
But
I'm
it's not
trying to
before the
ask
court
you-
also because you never raised it. So if we've never decided it, I thought you were telling us an eviction, it's not an issue, that's why you didn't move below based on an eviction. So you're saying we've never decided that, why didn't you move on that ground if you thought it was an eviction? Right? If you're saying we don't have to decide that today, it's open issue,
Right.
right? Why didn't you close it? Why didn't you move under the eviction law saying it's a closed container? I was evicted.
That's a fair point, but again, we don't know that in an eviction, there is in
I
fact a
wonder the
bailment
same
created.
thing, though, because the distinction between the premises and the property, if you had moved under the eviction, which is clearly preserved, we would be dealing with much more of the substantive issues rather than struggling with the preservation issue.
Understood, but again, we don't know for sure that an eviction creates a bailment. To the extent it does, it's much more
We might know
attenuated.
that. If you had raised it and everybody thought it was an eviction, we might have some grounding on what was this, what did the marshal reasonably expect to do? We could have gotten into all those issues, and we would be reviewing that record instead of speculating on what would the marshal do if it was a box, if it was a jewelry box. We don't know any of that because none of this was fleshed out by the court. But I have a basic question, and I'm really just asking for information. There's a discussion of your client having a lock on the door and this expectation. Is that anywhere in the record at the suppression hearing?
No, that comes up at trial.
The argument really at the suppression hearing was this eviction isn't legal.
Correct.
So he never calls the cousin or whoever to come in and say any of that. So even that isn't in the record in the suppression hearing.
Not at the suppression hearing, comes out of trial. And again, we're not arguing for standing as to the bedroom. We're arguing for standing as to closed containers, which again have a special primacy within the Fourth Amendment. That's all we're asking for, and I think it's important for this court to contrast that with the position that the people are taking, which is that no one, not my client, not any of the 20,000 other people in New York every year.
was
I
that
guess
your
some of the
argument?
questions
Was that your
are, but I
argument
guess
below?
some of the questions are
Yes.
whether your client could have argued, or counsel could have argued, that regardless of whether or not it's an eviction or a legal possession, they're closed containers, and there's a reasonable expectation of privacy in the closed containers, regardless of how the marshal ends up at that apartment.
Yes, Your Honor makes a good point, but again.
Other colleagues have made that point, and I'm just
Yes, but
repeating what
again,
they have said.
defense
So the
coun-
question is, why wasn't that argument made?
It was made in the context of the merits. As we were discussing before, there was this cascading argument, so to speak, in terms of how the cop gets from upstairs to downstairs, how he gets from the threshold of the bedroom to inside the bedroom, how he moves from one place in the bedroom to the other, so on and so forth, until you get to the closed containers. So yes, the argument could have been made in the context of standing.
On the merits, was it based on an expectation of privacy given the relationship, or based on their closed containers, you can't open them just because you see the closed containers?
I believe it was the latter, Your Honor.
Thank you, counsel.
Thank you, Your Honors.